I'm here. I'm Donna Rex.
Thank you. Trustee Miller, welcome.
Welcome. Nice to meet you all.
I'll call the Town of Lyons Trustee meeting, special meeting of November 24th, 2020 to order. Could we please have the roll call, Madam Clerk?
Yes, Mayor Angelo.
Present.
Mayor Pro Tem Browning.
Present.
Trustee Caravis.
Present.
Trustee Lowell.
Present.
Trustee Miller. You did say present, right? Okay, your volume isn't working, Wendy. Trustee Waugh.
Here.
And Trustee Rogan.
Present.
Please all rise and recite the Pledge of Allegiance. I pledge allegiance
Pledge
to
allegiance
the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Next on the agenda is audience business. This is an opportunity for anyone in the audience to address the Board of Trustees at this time. Is there anybody in the audience that would wish to address the Board of Trustees? Please state your name and address for the record. Madam Clerk, do you see anybody that wishes to address the Board of Trustees at this time?
No one's raised their hand, sir.
Okay. We'll move forward then. Under general business, item 1 is the Lions Den compliant issues. Could we have staff report, please?
Oh, excuse me, Trustee Waugh is trying to get your attention.
Trustee Waugh, pardon me. Trustee Waugh?
We can't hear you.
You can't hear me?
I could not unmute.
Oh, there we go.
Mute for several minutes because it was locked. I would just like, before we close audience business, I would like to just point of order. This is the last opportunity on tonight's meeting where there will be an opportunity for anyone from the public to speak. Is that correct?
Counselor?
That's correct. And I too was trying frantically to speak to the board, but couldn't do so because I was muted. But for those here wishing to speak on the Lions Den issues, they should do so during audience business. And so there's a number of people here that look to be here to speak on that issue. So I would encourage them to speak in audience business now.
Thank you.
With that understanding, is there anyone in the audience that wishes to address the Board of Trustees? Please state your name and address for the record.
Yes, Randall Yarborough, Lions Den.
Address?
160 East Main Street, Lyons, Colorado. I'd just like to address the issue at hand. I was reading over the code and ordinance today, and this all happened very quickly for me. I was under the assumption that I should have received a written 7 days notice as to what's going on. You know, I read the agenda, and my first point is I read Sergeant Chris's letter to the board, and there's some discrepancies there. The main one being that he said I cursed at an officer, which never happened. And I want to make that clear to the board. At no point did I say, and I quote, "fuck the Board of Health." Okay, that is unnecessary and it never happened. I have video of all 3 days. I have witnesses. Never once was I uncordial to the responding officer. And I just want to, make that clear for the record. We are trying to stay in business, and the only way to stay in business is to open our space for indoor dining. It's very hard with the second shutdown to survive. We're talking about employees losing their jobs. We're talking about money invested to own a business, to run a business successfully. And I am looking for some time frame here to seek counsel. I have not even had an opportunity to seek counsel. If I could get that extension, if that's what it requires, of 7 days. There was a mention of 15-day period for a hearing. I'm unclear if this is that hearing. Within 2 days, are we having this hearing that I understood would happen within 15 days? I don't know what that means. I'm unclear on that subject as well. So, I am here to represent myself and my restaurant, and I'd like to see what the Board of Trustees has to say on the matter.
Thank you. Thank you, sir. Would anybody else wish to address the Board of Trustees at this time?
Yes, my name is James Shearer. My address is 2301 Pearl Street, although I just moved into a house on 5th Street here in Lyons, Colorado. And I would just like to say that, these new lockdown restrictions are not only dangerous to every small business, especially the restaurants, but all small businesses and to the future of the town of Lyons. What you Board of Trustees are entrusted with and empowered with is the protection of your citizens. And with these lockdown restrictions and the inability for these businesses to run normally, you're going to destroy every restaurant and every small business in this town. There will be no tourism. There will be no economy. And I'd also like to reiterate, I was one of the witnesses here when Randall was addressing the police officers. And I think it's very problematic that you have someone employed with you, Sergeant Christ, who is willing to lie to push an agenda that really is dangerous to every single citizen that lives in Lyons, Colorado. So I really would like you guys to strongly consider what you're imposing on every single business here. And the power that you have affects every single person that lives here. And it's very dangerous what you're doing.
Thank you. Would anybody else wish to address the Board of Trustees? Madam Clerk, do you see anybody?
No, no one's got their hand raised.
Thank you. Then we will move on. Lions Den compliance issues. Staff, background, please.
Mary Angela, if I may begin by just kind of pointing out procedurally what is happening today, just to alleviate any confusion there may be as to what, one, has occurred, and two, what was happening here today at this meeting. So I'll let other town staff speak to factually what has happened with the Lions Den, but procedurally, here's where we are at. Yesterday, the board, the town staff, along with the sheriff, issued a temporary suspension of liquor license, and that's done pursuant to the state liquor code, which can be done without a hearing. And that can be done for two reasons. One, for temporary suspension due to breaking of any laws or orders. And then two, there's a new provision that's been added concerning public health orders specifically. And so that suspension was posted pursuant to both of those state regulations. Secondly, there are, that breaking, suspected breaking of, I don't know what's going on. Someone took over the screen. Thank you. That suspension of the license can also lead to two other things, which is one, a potential revocation of the liquor license, and then also revocation of the business license as well. What we are doing here today is not the public hearing on revocation of either of those licenses. Those must be done after notice and public hearing. For the business license, that's a 7-day notice period. For the liquor license, it must be done within 15 days of that temporary suspension. It's my understanding that town staff is noticing both of those public hearings. And so what the board is really doing here today is one, understanding the factual background of what has occurred, and then two, based on that factual background, directing staff whether or not to schedule those revocation hearings. We're not here to decide whether or not the licenses should actually be revoked. And I would strongly encourage the board not to pass any judgment on that at this time. It's simply whether there's enough factual information in the record to schedule those hearings. That is the sole purpose of what we're here to discuss today. And so with that in mind, I would just encourage the board to keep their discussions limited to those parameters.
Further staff background?
Both Sergeant Christ has his report and Town Clerk Vasquez her report with the state.
So I'll go ahead and start this off then, if it's up to me. Okay. So I'm just going to wind the clock back up a little bit till November 19th, Thursday. That was a day in court where Mr. Yarbrough had to appear on some multiple issues regarding noise that had been going on. That's irrelevant into this case right now that we're going to talk about tonight. However, at the end of that court hearing, he was advised by Judge Brown that he needed to conform to the new public health orders that were going to be in effect Friday the 20th. So on Friday the 20th, we responded at about 5:30 or 6 o'clock over to the Lions Den on multiple complaints of indoor dining, people gathering inside, shooting pool, things like that. Nobody social distancing, nobody wearing masks. The officer that went there, who was not me, went over there and dealt with it and explained the rules and regulations, I believe, to Randall or staff. And we left. We gave him a warning at that point that he needed to obey the public health order as it was written. Saturday night, we received basically the exact same call, this time from multiple different people. We went back in there and there were 6 people shooting pool, people gathered in the dining area, people at the bar, again, not social distancing, not wearing masks. He was confronted one more time, Randall was, by the officer that was there. We went back on Sunday night for another complaint. And prior to after my officer went over to the Lions Den on Sunday night and reported back to me what he had saw and what was going on, I contacted my legal advisor through the sheriff's office, Dia Lindsay, and spoke with her about this. Our directive from the sheriff has been, ever since COVID-19 started and the public health orders have come out, that unless issues were outrageous and we were getting blatant violations, that we were going to remain as neutral as possible. We were going to go out and warn people, educate people, and try to rectify the situations when we were called upon to do so. Well, it became clear to me that this just wasn't going to rectify. So I made that call to her because we do have the authority to issue a citation in this manner. Part of our protocols that were handed down by Sheriff Pelley were to make that call to our legal advisor first, and also to District Attorney Ken Kuffner. He is one of the guys that is kind of heading up this part of law on the civil side of things. So I spoke with him at length that night as well. Based on all the history and the non-compliance 3 days in a row, both my legal advisor and Ken Kuffner advised me to go ahead and issue the Lions Den a citation for failure to comply on the public health orders, which is what we did. Subsequently, after that, I met with town staff, and after a lengthy discussion there, it was determined that one of the ways that we could protect town and protect the public health order and the potential spread of Corona-19 virus, which I was told today, Lyons is currently at 38 cases, and that's underreported based on the PO box addresses. But in order to protect and keep the well-being of the citizens and visitors of Lyons, it was decided that we would revoke the Lyons Den's liquor license to prevent people from congregating in the restaurant. Those are the facts.
And if I may clarify, that's a temporary suspension of the liquor license. It's not a final revocation, which must be done pursuant to public hearing.
Correct.
Clerk Vasquez, do you have anything else to report?
No. After all the staff met together, clearly we were unsure how to go about dealing with this. So I did reach out to the state and the Liquor Enforcement Division, and they provided the guidance on how to carry forward. And ran that by our attorney as well. And then, as a matter of fact, just this morning, the same liquor enforcement investigator that had advised us on what we could do as a town, he called this morning because, as he put it, the volcano has erupted, and they're seeing several of these cases across the board. And they really don't like to go with a summary suspension. Their goal was much like the sheriff's office, to educate, to try to get people to comply. But he called this morning and he said he ran it by his boss to make sure that everything was okay, and that the state is now going away from education with, as he called them, blatant disregard for the public health order, and that they too will be issuing the summary suspensions. And he did ask if the town needed any assistance with this case, but I told him I would let him know what the board decided to do and keep the state updated on that. And that's about it.
Administrator Simonson, do you have anything to add?
No, I believe, excuse me. I believe the sergeant and the clerk have covered that. Other than the fact that, of course, we're getting numerous phone calls from the public about their concern of what's happening at the Lyons Den. Every day we get a handful of complaints from people asking why we're not enforcing. So that is all that occurred.
Thank you.
Administrator Simonson, if I may, did we not also send the owner of the Lyons Den a copy of the public health order on Friday?
I also actually, yes, twice I sent an update. I reminded him about the public health order on Friday, and I sent him a copy of it as well as his attorneys. Told him that here's a copy of it in case you need it. Judge Brown had also reminded him that on Thursday, and I sent it on Friday. And then I did also send him simultaneously with the posting on the suspension of his license that we were doing that as well. It's my understanding that the clerk and the sergeant posted the business around 2 o'clock on yesterday. Was it yesterday?
Yes.
And by 3:45, those signs had been torn off. Or removed. I shouldn't say torn off, removed.
Are there any questions by any of the board members at this time?
Mr. Mayor, can I add a few more things? I'm sorry I'm not on camera. As you know, I had shoulder surgery last week and can barely put on a shirt, let alone a tie.
Okay.
I just want to add a couple more things before we move forward.
Okay.
Thank you. So I just want to make a couple other things clear, based on some of the comments. That one, this public health order is not put out by the town. It's put out by the state and enforced by the county. And so that's really what is at play here for the most part. And that public health order ties back to both the liquor license and the business license, which require compliance with all orders, lawful orders and regulations. So I just wanted to, factually point that out. And then two, that there still may be additional things that may happen regarding this case. Boulder Public Health also could put out a suspension as well for due to the public health reason. As you might imagine, they're currently very swamped with this issue. But that's a separate process outside of the town's hands that may or may not occur as well. And so I just want to keep everyone apprised of that also. And so I don't think I have anything else to add, but I just want to make sure that those additional pieces of information were up for the board's consideration on whether or not revocation hearings should be scheduled.
Mayor Angelo, our Assistant of Counsel, Rick Martin, would like to speak.
Too late.
No, it is too late. I'm sorry, and I apologize. We are past that point.
There will be an opportunity for the Lions Den
Mayor
to
Angelo,
address
He
these
was
issues
trying to
at a
speak,
public
but
hearing.
everyone was muted. And so, not everybody who wanted to give public comment was allowed to do that because the meeting, whoever's running this meeting didn't have anybody able to unmute. So we would appreciate that and like to make that motion to allow our council to speak.
I asked, there are ways other than being unmuted, but being on the screen and raising one's hand to be recognized. At this time, it is improper to have any other further comment from the public. The public comments time has been closed. Are there any questions, Trustee Wah?
Could someone describe to me what the summary suspension, what that entails, and is it currently in place? And what that means in terms of the business's ability to serve alcohol and serve customers?
Council?
Yeah, so the summary suspension is a suspension for the liquor license only. So currently, the property is unable to serve liquor legally. And that is in place until a public hearing can be held on whether or not revocation will happen, or if the board decides not to schedule a revocation hearing, that suspension will be lifted. And so currently, and until either of those two things occur, the premises is not permitted to sell alcohol, both under the town's enforcement and under the state enforcement as well. It does not preclude the business from selling other kinds of food, so long as that's consistent with the public health order. And so that's currently the state of what they are allowed and not allowed to do.
Thank you for that clarification.
Any other questions? Mayor Pro Tem Browning.
Yeah, I have a question about the timing. If notice goes out today of a hearing on possible license revocation or suspension, and I'm talking about the liquor license at this point, then that notice period has to be 15 days. But as I understand it, the summary suspension was done yesterday. Yep. So what happens if 15 days passes from yesterday before we have a hearing?
That's a great question, and something I believe talked to the state with yesterday. And the case is not that notice has to be 15 days for the revocation hearing. It is simply that it has to be done within 15 days. And that I think it's recommended that's 10 days is the applicable notice period. And so that's what the town has noticed, I think, already at this point, just as a precaution for the revocation or suspension hearing.
Okay, so the notice period for the possible revocation or suspension can be less than 15 days. It's just that the summary suspension can't last more than 15 days. Is that right?
That's correct.
Okay, thank you.
Any other questions by the board? Council?
Yes.
What is our procedure?
So on the agenda, we have three separate items scheduled. I'm not sure, I don't have it in front of me, but I would prefer we go through each of those individually and the board offer its direction on whether or not the town should proceed with noticing the revocation hearings. And there are additional facts on the STR issue that I'm myself, I'm not entirely clear on, that we should probably address separately, but we should go through each of those items and say whether or not the board believes a revocation hearing should be scheduled. And once again, I would just caution everyone that this is simply for scheduling. It's not for final judgment on whether or not the licenses should be revoked or not.
The first one is business license potential suspension. What kind of notice is required on that, council?
7 days. And
7 days.
correct. And then when that hearing does occur, both the town and the holder of the license will be able to present testimony. There will be public comment. It'll be a full quasi-judicial hearing when it happens.
And do we take a vote on whether we want to schedule that hearing?
Yeah, just a plain vote, no comment.
Okay. Let's vote on item A, business license potential suspension, 7 days. Madam Clerk, could you please call the roll?
And this is just to direct staff to schedule that, just to be clear.
Right.
Mayor Angelo,
Aye.
Mayor Pro Tem Browning,
Aye.
Trustee Caravas,
Aye.
Trustee Lowell,
Aye.
Trustee Miller,
I believe she said aye.
yeah, Trustee Waugh,
Aye.
and Trustee Rogan.
Aye.
Staff has been directed to, as such, to schedule the business license potential suspension. B is a liquor license suspension, and that will occur, I believe, in 10 days, council?
I believe the clerk will have to clarify. I believe that's what it's been noticed for if the board decides to proceed with that proceeding.
Okay. I'll call for the vote on that. Madam Clerk?
Mayor Angelo,
Aye.
Mayor Pro Tem Browning,
Aye.
Trustee Caravas,
Aye.
Trustee Lowell,
Aye.
Trustee Miller, Trustee Waugh,
Aye.
and Trustee Rogan.
Aye.
The liquor license suspension hearing is to be scheduled per board decision. C is the STR non-compliance. Could we have some background on that, Administrator Simonson?
Sure. As part of the complaints that we received over the past few days, one was that it was called in that there are people living and partying upstairs in what is not a living unit above the restaurant and the bar. At this point in our research, I don't find, that is not confirmed. It was an issue that I did check into. It is not a short-term rental. It is not an accessory dwelling unit licensed by the town. However, the reports of people being on the roof and drinking and being out past the timeline that they were given for their noise ordinance just brought this to our attention. So at this point, I don't have any other information other than the fact that the fire chief and the building department has said that unit is not appropriate for living or any type of residence. So that may come up again during the business license discussion, but at this point, I wanted to address it because others were reporting that people are living there and they should not be.
Okay, thank you. We don't have to take an action on that. We'll do a little more research on that. Council, is that correct?
That's appropriate direction to give to staff. And, another option available to staff as well is that we can file for an administrative search warrant if reports continue. And so I just want to make sure that the board is apprised of that option. That's one potential option available for investigating this matter as well.
Okay.
Point of clarification, please.
clarification. Trustee Caravas would like clarification. Sir.
On this STR issue, is this a complaint towards the owner of the building, the landlord?
No, at this time, the report was that people had moved from the patio up to the rooftop to continue after hours drinking. But I did not find there was enough information confirmed to bring that forward to you today.
What about the complaints of people living? Are the complaints living on the roof too, or is there an actual space?
There's an office unit that was built up there. It did have a small kitchenette and bathroom. It was licensed to be an office space when it was a previous restaurant, and then it was after that another business used it as part of their licensed premise to store alcohol in for the restaurant and bar. The report to me was that someone is living there, and that instead of being out on the deck, they've just moved it to the roof. So I had listed that as you heard earlier, this all happened quite quickly, and I was trying to address all of the different complaints and concerns that were coming in. The furthest I got was that this is not licensed for any use right now other than a storage unit.
Okay, and so I think the way our codes are written is a leasee cannot apply for an SDR anyway, so it has to be the landlord. So make sure we notify the landlord that he's being brought into this too.
And Trustee Caravas, you're exactly right. If there were to be a complaint by the town municipal court, it would involve both the landlord and the people causing the code to be violated, as was the case in another recent violation of the STR code.
Okay, thank you.
Any further questions? Thank you. Madam Clerk, could you please read Resolution 2020-182 into the record?
Yes, Resolution 2020-182, a resolution of the Town of Lyons, Colorado, awarding and approving a professional services agreement with Western States Land Services, LLC, for a right-of-way consultant for FEMA-funded project, 2nd Avenue Bridge replacement.
Staff report, please.
Thank you. Tracy Sanders is on the phone.
Okay.
Yes, so we were not able to acquire a condemnation attorney. However, the right-of-way consultant will take all the steps necessary to go to litigation, so we would need this anyway. So they will go and they'll bring in an appraiser, they'll appraise the property and the impact to the property. And then they will negotiate with the property owner and do all the appropriate public notifications needed to follow the Uniform Relocation Act, which is generally needed when you're utilizing federal funds for a project. So if we do need to go to litigation, they'll wrap it up into a package for us. And we would still need to acquire an attorney, which I think we found another option for that if we need to do that. So this is just the preliminary steps that you need to do if you do need to go to condemnation and into litigation.
Thank you. Do we have a motion to approve Resolution 2020-182? Mayor Pro Tem Browning.
Mayor, I have a couple of questions first of staff on this one.
Okay.
The contract that's proposed with this company references that if the anticipated appraisal value is less than $5,000, as I read it, the town, the appraiser, the company we're hiring would not do their own appraisal, but would defer to the property owner to do an appraisal, and the town would pay for the property owner's appraisal. Did I read that right?
I think the reason why it reads that is because under the law, if the value to be acquired is less than $5,000, then there doesn't need to be an appraisal to proceed towards condemnation. I think that's what that provision is trying to get at.
Okay. There was language in there about the town paying for the property owner's appraisal, and that
Yep.
I didn't quite understand
And
why
if we
we
were
should
to
do that and how it would work.
yeah, we would, if we were to proceed towards condemnation in order to make, have an ordinance approving that condemnation, we would be required to pay for the property owner's appraisal.
Oh, that's the way the Uniform Relocation Act works, or whatever it's called.
That's the way Colorado state law works, but I think most states are
okay.
pretty much the same on that.
And then my other question was, obviously, we've had trouble retaining a condemnation attorney. That's something that the board authorized, directed a couple of times. I didn't see anything in this contract about the contracted company providing assistance to the town or recommendations or anything about a condemnation attorney. Is that something that's understood that they're going to do that as part of the process, or what's the procedure if they try to negotiate something with the property owner, which our staff has been trying to do for a long time, months and months, but they're not successful either? How does this advance the ball toward us hiring a condemnation attorney?
So they'll do all the legwork for us with the negotiation and the appraisals, and if they can't come to an agreement, then they would give us a full package of all the negotiations and the appraisals and such. And then I did talk with Attorney Dittman, and I believe we could just, they could bring on a contracted attorney through their firm and just bill us for a condemnation attorney through their firm if we need to go that route.
Basically, they have a lot of contacts with condemnation attorneys.
They have one that, go ahead, Brandon.
Yeah, so the issue with acquiring a condemnation attorney in the past was that no one was willing to deal with the CBDGR and the FEMA compliance mechanisms. It wasn't the fact that no one was willing to do the project. Is basically the feedback we got was that this project is so small, it wouldn't be worth us to do all the compliance stuff if FEMA was going to pay for it. And so there are multiple firms lined up and ready to do this work if the town will pay for it itself, rather than being paid with federal funds. And what I had discussed with Tracy is that, we could have a condemnation attorney tomorrow, if we had board authorization, I think we already do, to hire them through our firm and just bill as we do with other experts through our contract. And so there's a firm we use quite frequently that actually got further along the process of bidding on the project than anyone else that we would recommend using, and they would serve as the condemnation counsel. And the right-of-way consultant would simply be basically the retained expert on the appraisal and all the things that are necessary, notices necessary to proceed under the Uniform Relocation Act.
Okay, I just wanted to make sure that was still an option and understand how it was going to happen. So thank you.
And my understanding is that this firm has worked with this consultant before. It's just, the issue has been the FEMA funding, not so much acquiring counsel.
Okay, thank you.
Further questions? Trustee Caravas.
In the agreement, it was stated that they will begin the negotiation process. This board has given direction, no more negotiations, a specific original amount, that's it, condemnation. So why are we going against what this board has directed multitude of times? What parameters are they going to use to negotiations? That maximum amount we gave direction to the staff the last two times, which is the original 9,000 amount, and that's it?
Well, they're going to do an appraisal, and I think that we'll have a little more of a, something to back up the offer that we're making with an appraisal. But this is just part of what we have to do for the URA process. We have to show, that we got the appraisal and we did the negotiations, and I think there's some public notice that needs to take place. So this is ensuring that we're following all those steps.
Can you remind me why we didn't do this in May then?
Because honestly, I did not have any information on how this process worked. I talked to the state. They didn't have any direction for me. I talked to the Boulder County Collaborative. They gave me some minimal direction. So there was really no guidance on this. And it's still, unclear if we have to follow URA, but it was highly recommended by the state that we do it. So honestly, it's the first time we've run into this since we started flood recovery, and I'm getting minimal to no guidance on this. And
Well, it
so,
sounds like you're the new go-to person for the state. I'd put that on your resume if I were you.
so but Wes, this contractor consultant has experience with URA. So we just want to make sure that we're following all those steps.
Yep, thank you. Appreciate it.
Trustee Wah.
Well, with that said, I would rather offer the homeowner an additional $10,000 and save the town $5,000. And if they don't take it, then we move forward with the commendation attorney. That's my recommendation. I think this is unnecessary.
Right now, the homeowner is being offered about $16,000. Just as a reminder.
Okay. Well, we're going to spend $15,000 to have them say that that's not enough. So, and to do an assessment and then call a commendation attorney. Why don't we just sweeten the offer with some of that $15,000? And if they don't take it, we'll move forward with commendation. Seems like simple economics to me.
So offer them 26,000.
It's a recommendation.
Okay.
Mayor Pro Tem Browning.
I think the trouble with doing that is if you offer them 15,000 and they say no, then you're gonna have to do all this anyway. And all you've done is we've been making them offers for months and months and months. And I think at this point, we should just proceed with the legal processes as recommended by council and staff, because these people are not negotiating in good faith, in my opinion, and that's been the board's discussion. So when somebody's not negotiating in good faith, making them a higher offer than before, I don't think is the way to proceed. I think we should just proceed and as recommended by council.
I think the goal is by hiring experts, including the right-of-way consultant and the attorney, is that to show them that people who are experts in this field show that they're acting unreasonable and bringing them back to the negotiation table in a more favorable disposition. And I can tell you that since we've started this process, that suddenly they have gotten more reasonable to a certain degree, and some of their demands, such as that the town didn't have authority to condemn the property, have suddenly evaporated. And so this process is starting to bear fruit, just not as quickly as we wanted to. But I think getting one experts involved that have a lot more background in this will help speed up the process, and hopefully we won't need to go all the way to the finish line once we have people who are knowledgeable on this issue and the law in this area, telling them what the facts are, and that simply their demands are unrealistic.
Any further comments? No further comments by staff?
Yeah. Trustee Lowell has this hand up.
Trustee Lowell, sir.
Yeah, thank you. I tend to agree with Trustee War on sweetening the deal, but then I can see Mayor Pro Tem Browning's points as well. I guess my issue with this is if we okay this resolution this afternoon, and then we go forward with it, that information is going to be made available to the property owners. In other words, I guess what I'm saying is this sort of a veiled threat to the property owners that they best accept the 16K that we've already offered them? And if it's true, then this contract that we're approving tonight, how much of that would be spent at that point? Do we still have to pay the full amount of the contract as indicated in the resolution, even if the owners finally agree? I'm just curious.
You pay for work. You pay for work performed, so they're not guaranteed the full contract amount. It's for the work that's performed. So if we end up coming to an agreement before we, get to negotiations, then we can end the contract at any time.
So
the
what-
hope is if we put people in place that we will have to spend very little money if we are able to come to a resolution.
So excuse me, but is this the figure that's proposed in this resolution, is that a not to exceed amount then?
Yes.
Okay, thank you.
Further questions? I'll entertain a motion. Mayor Pro Tem Browning.
I move that we approve resolution and adopt resolution 2020-182 for professional services agreement with Western States LLC as a consultant for the Second Avenue Bridge Replacement Project.
I'll second that.
We have a motion and a second as stated. Further comments? Seeing none, I'll call for the vote. Madam Clerk.
Mayor Angelo,
Aye.
Mayor Pro Tem Browning,
Aye.
Trustee Caravas,
Aye.
Trustee Lowe,
Aye.
Trustee Miller, Trustee Waugh,
Aye.
and Trustee Rogan.
Aye.
Resolution 2020-182 passes unanimously. Hopefully we'll see that bridge sooner than later. I'll entertain a motion to adjourn.
So moved.
This meeting is adjourned. Thank you very much, everybody. Happy Thanksgiving.
Happy Thanksgiving.
Thanksgiving.